Matters. My name is Jeffrey Davis. I'm here in the Money Matters Radio Network studios with Gary Fatigue, and I love being here with you on Drive Time.
It's really exciting. It's great that we've been able to move to this new time slot, and our listeners are finding us, and it's been great. Got a very interesting guest today, our regular reporter, Mark Furman from Tarlow, Hart Rodgers. Mark.
Gary, Jeffrey, nice to be with you today.
Nice to be with you too.
I wanted to talk about a discrimination case that was recently decided by the Federal District Court in Massachusetts. Discrimination cases are always coming up, and employers need to be aware of how they need to handle potential situations. This involves a hearing impaired person. So the claims were handicap discrimination and retaliation and a failure to reasonably accommodate a otherwise qualified handicapped person. So I'll give you a little bit of a quickie background of the case. A woman worked for Bay State Health Systems for about 10 years. And she did quite well starting in 2000 and eventually got promoted to a position where she was a recovery audit coordinator in the Health Information Management Department. It was a substantial promotion for her. And almost from the time that she was promoted, she ran into a whole series of problems. She was accused of not responding to auditors' request letters, for failing to gather medical records, to meet certain time deadlines. She was talked to by her supervisor. She was accused by an auditor for missing other deadlines. She started to get into a little bit of job performance issues with her new job. Ultimately, she was accused of giving auditors the wrong records in a particular case. She was issued a written warning for breaching confidentiality policy by copying an outside vendor on patient records. And she was given another warning for other oversights in connection with her job. Nothing that was considered willful misconduct, but things that didn't meet the employer's requirements. So eventually the supervisor got complaints from other employees, and careless errors were alleged, not answering inquiries, poor communication of information, not performing trial audits, problem after problem after problem was alleged. She was given a 1-week administrative leave with pay for not completing a mock audit exercise, and when she returned, she was put into what was called a performance improvement plan, PIP. And there's a whole series of things she had to do, and she had to meet with her supervisor 3 times a month, and eventually she talked to the HR folks about finding a different position in Bay State. Finally, on September 1, after all this 2010, after all of these incidents, she asked in writing for a reasonable accommodation because she had a hearing impairment, and she wore hearing aids in each ear. And she said she was having trouble communicating with the supervisor because of that. There was a meeting with the supervisor and the HR person 6 days afterwards, and it was a difficult meeting in the sense that, she had suggested a particular kind of device that would be used and involved recording conversations with the supervisor. There were concerns expressed about whether you can legally record communications with other people. But her request for reasonable accommodation was forwarded to the ADA department, the American for Disabilities Act Compliance Department, and I guess frustrated, and she said that she thought she wasn't going to get an accommodation, so she resigned the very next day. She had not been denied the accommodation. She left before the process was implemented. So she claimed that she was effectively constructively discharged by the company, and she sued for retaliation for discrimination on the basis of handicap and the failure to give reasonable accommodations. So anyway, so some of the counts got dismissed early in the case, and after discovery, after the employer has spent a lot of money in depositions and the like, the employer moves for summary judgment seeking to dismiss the entire claim. And the court did dismiss the entire claim. So just how it works is to prove a discrimination based upon a failure to accommodate a handicapped person. You got to prove you're handicapped, that you're qualified otherwise. The employer knew of your disability and didn't reasonably accommodate the request. Here, the finding of the court was, well, even if she was qualified, which was questionable, the employer was in the middle of pursuing an accommodation for her. The accommodation hadn't been denied, and she just quit. So the court said she loses on the claim of failure to accommodate. Secondly, on the claims of discrimination, we've talked about this a little bit, but we have this complicated shifting of burden approach that the law takes in discrimination case. She has to establish she's disabled first, that she can perform the essential functions. She had adverse employment action, and the adverse employment decision was based on her disability. Well, here, there wasn't an adverse employment action, the court said. Even remember, she had that administrative leave.
Right.
She was paid for it. Her accommodation request wasn't turned down. She just quit. So because there was no adverse employment action, there could be no discrimination. Finally, she alleged that there was a hostile work environment and she was retaliated against. The court found that there was no evidence that was sufficient to establish a hostile work environment, that the employer acted in a very deliberate and professional way. She wasn't fired when she asked for accommodations. They continued with the performance improvement plan, submitted her request to the ADA office of the company. She basically quit, is what the judge is saying. That wasn't a sufficient basis to quit. And similarly, there was no retaliation. Again, she wasn't fired, she quit. So she wasn't demoted. She didn't have her pay reduced. She wasn't suspended. There was no employment action adverse to her. The court found it was just a case of quitting. You've got to go. The message here for employers is, if you have wind of somebody who has an impairment, who may be disabled within the meaning of the law, you have an obligation to reasonably accommodate them. Of course, the employee has obligations too. One is to notify you that they need the accommodation. You don't have a duty until you have notice from the employee of the need to accommodate. And you have the obligation then to seriously evaluate what you can do that's reasonable to accommodate that person. Is there another job? Are there certain accommodations that can be made within the existing job so that they can perform the duties? The cases are serious. Here the employer was found to have done nothing wrong, but there's a lot of cases where employers don't take seriously their obligation to provide reasonable accommodations to otherwise handicapped person. Get legal advice early in the process too.
Oh my, I could do a whole show just on this story. I don't know where to start. It's, I do developmental plans and strategic developmental plans for employees and have done it for 35 years. So many things about this employee being left alone for so many years, living in this sort of world and believing that they can get away with stuff. The employer taking so long to deal with this person, helping to create this perception. Just the whole timing of the thing. I when I coach people ask me after 2 months of coaching, do you think the person can change? Not 2 years. Do you think the person can change? I mean, this is clearly a person who does not have a good an accurate self-perception of himself and of themselves, and it just behaves in such a way that's so inappropriate. And even I think what the employer probably did, the way I read between the lines is, and I've seen this in a lot of coaching, is the person became so aware of how they weren't functioning properly in the organization that they resigned. It was their best option. And then they realized and then they realized maybe that, that they were being pushed a little bit to go because the employer was scared of discrimination, gender issues, was she over a certain age? But again, I think, when you're in business, you're saying it, be clear with people, deal with people, don't let things fester, get it out, and just deal with it right away, and give them a chance to change, but be clear what the milestones for improvement are. I mean, this whole thing of, you said it was 10 years?
Well, she got the promotion. She got the promotion. She started out as a switchboard operator, then a patient accounting Medicaid
But she
billing
wasn't
clerk.
filling it.
Then she was promoted in September '09.
But she wasn't doing the audits, she wasn't doing the paperwork,
But that
she
was
wasn't treating people right.
I think she did her performance problems came after she was promoted.
After she was promoted. So she got
In
in over her
September
head, it
'09.
sounded like.
She was placed in the wrong position,
Right.
it seemed like, and they did wait, it looked like, for close to a year before they put her in this performance improvement plan.
Exactly.
And they had all these incidents. It looked like they went from the problem starting shortly after she got this promotion all the way until June 2010 before she got into this performance improvement program. And the supervisor knew she had a hearing aid in one ear, and then but a lot of people wear hearing aids. That doesn't mean that you need any accommodation. Then she got a second hearing aid, but it was only in September that she communicated this issue. But she was having so many problems, and not just with the supervisor. Complaints were coming from a variety of...
I don't want to get a slew of letters criticizing me, but I know more people who were bad listeners, forget hearing aids, who don't have hearing aids, than I know people with hearing aids who are bad listeners. If someone's a good listener, they take the time to listen and try to make sure that they show people they're hearing something. And I think the hearing aid becomes a sort of a distraction.
Right. At one point, she tried to use as evidence the fact she asked for the assistant to the supervisor to attend their meetings to take note, transcribe everything. The supervisor, so that she would know what was said at the meeting. And the supervisor declined that request. So she tried to cite that as evidence of not accommodating or discrimination. Court didn't buy that meant anything, he didn't think it was appropriate for, it appeared from the case, for his assistant to be present during personnel improvement discussions with her under this PIP plan. So the court didn't buy that as evidence of discrimination, didn't buy the fact he knew she had one hearing aid earlier as evidence of discrimination. He made some comment, it was alleged at one time, like, I feel like you don't hear me, you don't understand what I'm
To me,
saying.
there's one bottom line. Let a problem fester, and it gets to be a worse problem.
Right.
When you're in business, you got to deal with problems quickly, especially, and people do delay too long on human resource problems. They give the people the benefit of the doubt. They don't want to bring in human resources, or they don't want to bring in consultants, or they don't want to talk to their lawyer. And when you have a human resource problem, it's only going to get worse.
The other things people do, that's absolutely right. The other things people do, though, is sometimes, entrepreneurs, when they come to a decision, they make it. It's ready, fire, aim,
Right.
instead of ready, aim, fire. And you have to, I urge people to get legal advice early in the process and not wait to get legal advice when you get served with a complaint with the Commission Against Discrimination.
Right. I go to clients and they ask me about employees. A lot of times I'll say, you need to talk to your lawyer. This is a situation, this is not just a coaching situation. Mark, if someone wants to get hold of you, how would they do that?
I can be reached at 617-218-2025 or at mfurman, Furman, at tbhr-law.com.
You can also be found on YouTube by typing in discrimination on the web. You'll also be found on our website, which is also, our new one is under construction. But we'll see you next week, Mark, on Radio Entrepreneurs.